Subscribe to our YouTube channel and press the bell icon to get the latest updates.
So, good afternoon, friends. Firstly, I must apologize for the absence of Mr. Yashwant Sinha, who has fallen ill, developed fever, so therefore he had been touring extensively, just came back yesterday, but unfortunately he has had fever, so he couldn't come. So, as you all know, this is about the Rafale review judgment that was delivered yesterday. So in order to understand the judgment, a very brief background about this case. As you all know that the three of us, including Mr. Yashwant Sinha, had filed a very detailed complaint with the CBI, pointing out various things that had happened in the Rafale deal, which included the fact that a new contract had been signed by the Prime Minister effectively, or a new decision had been taken by the Prime Minister unilaterally to substitute an old, almost done deal of 126 aircrafts to be purchased, out of which 18 were to come in a ready-to-fly condition and the remaining 108 were to be manufactured in the factory of Hindustan Aeronautics with technology transfer to Hindustan Aeronautics. That decision, which was taken after due process over several years, with the Air Force first giving what is known as the acceptance of necessity about what kind of aircrafts, how many aircrafts they need. Thereafter, the Defence Acquisition Council having okayed it. And when the deal was almost done, the Prime Minister went to France and unilaterally changed the decision to 36 aircrafts, with removing all the manufacture in India, removing transfer of technology, and just buying 36 ready-to-fly aircraft by greatly increasing the cost of each aircraft. And now bringing in a clause about 50% of the value of the contract being given to offset contractors, and bringing in Anil Ambani or his company as the offset contractor or as the main offset contractor. We had given a detailed complaint to the CBI, pointing out why these constituted offences under the Prevention of Corruption Act, and therefore the need for a thorough investigation in the matter. Now, when no FIR was registered for several weeks, and after the Supreme Court had issued notice on 2 other petitions and asked the government to give some information in a sealed cover, we also moved the Supreme Court, saying that the Supreme Court must order the CBI to conduct an investigation or constitute an SIT to conduct a court-monitored investigation in this matter. Now, unfortunately, the Supreme Court clubbed these various petitions. One of them had asked for scrapping the contract. And they dealt with our petition also. They dealt with all the petitions together. And our petition was also dealt with as if we were seeking scrapping of the contract rather than seeking an investigation into our complaint made to the CBI. And on that basis, and on the basis of information given to the court in a sealed cover by the government, which was not even shared with us, they proceeded to dismiss the petition by saying that this doesn't come within the contours of their jurisdiction under Article 32. And after seeing what the information that the government has given, they felt that there is no need for the court to embark upon a detailed investigation in this matter. On that basis, our writ petition was dismissed. When the judgment came, it contained some astounding facts which the court had taken from the sealed cover given to the court by the government. One of them was that a CAG report had been submitted to the Public Accounts Committee and had been placed before Parliament and in the public domain, which fact was totally false. Another fact mentioned in the judgment was that this Dassault company had been negotiating with this Anil Ambani's Reliance company since 2012, and therefore it could not have been the Prime Minister's decision in 2015 to bring in Anil Ambani. This fact also turned out to be totally false. Meanwhile, some more information came, and this further information, which was of several kinds, which showed that the Defense Ministry had objected to the Prime Minister's office conducting parallel negotiations, which showed that Mr. Ajit Doval had also been involved in behind the scene negotiations, which showed that the sovereign guarantee had been given up at the instance of Mr. Ajit Doval and others, which showed that all the anti-corruption clauses had been given up. This came out in a series of articles written by Mr. N. Ram in the... All the anti-corruption clauses in the contract, which are standard parts of such contracts, they had been given up at the instance of the PMO, which showed that French newspapers immediately after this Prime Minister's announcement of the New Deal in April 2015 had said that this new deal that the deal had been changed in order to bring in Anil Ambani. And the fact that the former French President Mr. Hollande, in whose presence this new deal had been struck, confirmed that Ambani had been brought in at the instance of the Prime Minister, and that they had no alternative. So therefore, in our review petition, we pointed out that your judgment is totally wrong, firstly because it doesn't deal with our prayer. Our prayer is to ask the CBI to order an investigation, and you are saying that the Supreme Court is ill-equipped to conduct an investigation. We are not asking the Supreme Court to conduct an investigation. We are saying that in accordance with the law of the land, once a complaint of this kind has been made to the CBI, it is their legal duty to conduct an investigation. They are not doing it, perhaps because of the pressure of the government, and therefore you order them to conduct an investigation. Then we pointed out that the court has relied upon information given to it, which information was not even shared with us, which is a gross violation of natural justice. Court cannot deliver judgment on the basis of something which is not even given to the petitioners. And much of it turned out to be totally false, and which contained suppression of the most important piece of evidence, which was the report of the internal negotiating team, in which the domain experts had pointed out emphatically that the price had been unilaterally increased, the benchmark price had been increased by more than 50% without any justification. Who pointed out that the delivery schedule is also worse than the delivery schedule of the original deal of 126 aircrafts. And yet, overlooking all this, unfortunately, the Supreme Court has dismissed the review petition, but by saying that we are asking the court to act as an appellate authority over the government. We were not saying that at all. We were saying that the court has completely misdirected itself from our prayer. Our prayer is to ask the CBI to do its legal duty and conduct an investigation on our complaint. But fortunately, Justice Joseph, in his concurring judgment, has pointed out, and I'll read out a few paragraphs from his concurring judgment. If you see the press note at page 2 on the top, we have pointed out that he has admitted, they have both admitted that yes, the information given by the government about the CAG report was incorrect, and therefore they accept the government's application for correction of the order. They accept that the information about Anil Ambani's company having been in negotiation with Dassault in 2012 is also incorrect. But they say that this is not important. But Justice Joseph in his judgment he says many things. He says that from the Constitution Bench judgment in Lalita Kumari, he says, though the stand of the government has been noticed, which is the second respondent in this petition, the party which has a say in the matter, or rather a duty in the matter in terms of the law laid down by this court in Lalita Kumari, is the CBI, before which the petitioners have moved this complaint. It is quite clear that the CBI, which is the premier investigating agency in the country, is expected to act completely independent of the government of the day. The government cannot speak on behalf of the CBI. Whatever that be, the fact remains that a decision in terms of what is laid down in Lalita Kumari is to be taken. And then they say that there can be no dispute that the CBI, which assumedly employs state-of-the-art techniques of investigation, professionalism of the highest quality which embraces within it uncompromising independence and neutrality, is expected. Again, the restriction which underlines the impugned judgment is the limited scope of judicial review and also the writ jurisdiction under Article 32 of the Constitution. It is as clear as a mountain stream that both these considerations are totally irrelevant for an officer who has before him a complaint making out the commission of a cognizable offense. And they say it is beyond dispute that the offenses which are mentioned in the complaint filed by the petitioners are cognizable offenses. And then they say it is my view that the judgment sought to be reviewed would not stand in the way of the CBI from taking action on our complaint in accordance with law and subject to it obtaining previous approval of the government under 17A. Now 17A in the Prevention of Corruption Act was introduced by this government, which says even though this had been declared to be unconstitutional earlier when it was introduced in the CVC Act, the same amendment has been introduced in the Prevention of Corruption Act by this government, saying that prior permission of the government has to be taken before even an investigation can be done by the CBI in a corruption case. So therefore the Supreme Court says now that this amendment is there, therefore the CBI will have to take permission of the government, and after that it is their duty to investigate this matter in accordance with the judgment of the Supreme Court Constitution Bench in Lalita Kumari's case. So, there is no impediment on the part of the CBI in now. Of course, they have wasted over 1 year. Our complaint was given last October. They have been sitting over this complaint for the last 1 year. We had written in our complaint that you have to seek permission of the government, for investigation. And that time given to the government to grant or refuse to grant permission is 3 months, maximum 3 months under the law. But they have not moved, so we are now asking the CBI director to move in this matter, seek permission of the government, and we now call upon the government also to grant permission to the CBI. After all, if they have done nothing wrong, if they are totally clean and above board, why should they have any difficulty in having the matter investigated, especially by an agency which is considered to be a caged parrot of the government? So, we have pointed out at pages 5 and 6 what were the additional grounds that we had mentioned in our review petition, that information which came to us subsequently, which goes to the root of the matter and shows this to be a corrupt contract, was all this. We have said that the withdrawal of the earlier request for purchase of 126 aircraft, that 126 aircraft deal had started even in March 2015, much before this new deal of 36 aircrafts was sanctioned by the relevant authorities, that is the Air Force Headquarters and the Defense Acquisition Council. We had also pointed out that the statement made by the government in their sealed cover, which the court has reproduced, that the deal ran into rough weather, old deal ran into rough weather because of some problems with HAL in manufacturing these aircraft. We pointed out that this is totally false. The then chairman of HAL has stated emphatically that there was no technical problem whatsoever in HAL manufacturing these aircraft. And Mr. Eric Trappier himself in his TV clip had said that in France itself, that we are very happy to work with HAL and we will soon be collaborating with them in manufacture of this aircraft. Then of course we had pointed out these parallel negotiations being conducted by the Prime Minister's office, which the Defense Secretary himself had pointed out in his note that this is not good, this is undermining the regular negotiations. We had pointed out that Doval was involved in these negotiations, who had no business to be there. He was not at all in any committee, in any official committee. We had pointed out that the domain experts within the Indian negotiating team had said in their report that the price is more, the delivery schedule is worse, etc. And all those other things that I mentioned. So, we hope and expect that the CBI will now move in view of this judgment, which is binding on the CBI. You see, there is a misconception. Some people feel that this judgment is only of one judge, Justice Joseph, and the majority consisting of Justice Kaul and Chief Justice Gogoi have dismissed the review. Yes, they have dismissed the review, but the majority, or the Justice Kaul and Justice Gogoi, have not said anything to the contrary to what Justice Joseph has said about the legal necessity of an FIR being registered and the matter being investigated by the CBI, of the legal need, imperative legal need and the command of the Constitution bench in Lalita Kumari's case. The Supreme Court has held in several judgments that where there are two judgments of two judges in a case, and even if the minority has said something about a particular issue on which the majority is silent, then that minority judgment is binding and prevails. Therefore, this part of the judgment of Justice Joseph, that the CBI is duty bound to investigate this matter after obtaining the permission of the government, is a binding judgment which binds the CBI. So we would request the CBI director to act in accordance with Justice Joseph's judgment and immediately seek permission from the government and start investigation.
Sir, these are, nobody could have explained these things better than Prashant, as you know, in all these matters. So I will only mention three general points, which will have far-reaching consequences, especially if the judgment is misinterpreted, as Prashant was just pointing out, in the way the government in this regard. So the first point is that if you take the amendment of that section 17A to which Prashant drew attention, which even the amendment was that not only before prosecution, but even before investigation, government, the government must, the government permission should be taken even before investigation. This was the thing. So that 17A, and he has given you the history of how that had been held to be unconstitutional, and yet it was reintroduced in another guise, and the Supreme Court has not struck it down. In fact, has relied on it. But the second point here is that this self-restraint of the Supreme Court, कि भाई ये बड़े sensitive questions हैं, हमें इनमें नहीं जाना चाहिए, we don't have the competence to do this. These two things taken together now means a completely the khuli chutti hai for wrongdoing in regard to defense matters and other matters relating to national security. For instance, if they purchase surveillance equipment to monitor your telephones, that's also national security. So in no matter can you now, with this self-restraint of this court and the 17A being changed, you can proceed. A good example, Prashant will remind us, is the story in The Wire about that Ukrainian AN-2, the transport aircraft, that the Ukrainian government has written to this government कि भाई इसमें कुछ खराबी हुई है, and we know such and such joint secretary who knows the details. So please tell us what we should do and what you are going to do. And the government has not replied to it. Now supposing you take that matter to the court. Court is a sensitive matter. Aviation transport. So we can't go into this. This becomes a very, very dangerous combination of 17A and this self-imposed restraint on by the court. And self-restraint about what? As Prashant has just pointed out, we never questioned whether the contract should go to Rafale or not. We never said that it should, that the technical competence of this aircraft is better or worse than any other thing. In our written submissions, we said the opposite. And Prashant said the opposite while speaking. I said the opposite while speaking in the court. That we are not questioning this, the technical capabilities of this thing. But the court says we should not go into law because we don't have the competence to look at the technical point, nor do the appellants. But we never asked for that. And so what are the questions, as Prashant was just telling us, what are the questions which we had raised, which the evidence pinpointed, and which the court says, no, we can't examine? Hey, is it a fact or not that the defense secretary himself wrote on file that there are parallel negotiations being conducted by the Prime Minister's office and that this is seriously jeopardizing the stand taken by the Indian negotiating team? ये उसने लिखा या नहीं लिखा? और इसको एग्जामिन करने में आपको क्या हिजाब है? What is the security thing that is imperiled if you examine this particular fact or not? Similarly, is it a fact or not that after 7 years of work, the Air Force and the whole team that was constituted determined that our aircraft are aging. The only new induction is Sukhoi. We need 126 planes. And suddenly that is cut down to 36. Does that not jeopardize our national security? But the court says, no, we can't examine this. इसी तरह जैसे प्रशांत ने कहा कि भाई मेड इन इंडिया होना था, अब तो मेड इन इंडिया क्या हुआ था, वो 2 नींबू और 1 वो नारियल, वो जो अभी यहाँ से ले थे राजनाथ सिंह हमारे दोस्त, वही मेड. You give up the entire question of technology transfer in this regard. Secondly, is it or is it not a fact that this was unilaterally decided without any consultation whatsoever? We have already drawn your attention, we drew the court's attention to this statement, to the press briefing of the Foreign Secretary, now the Foreign Minister, 2 days before the Prime Minister lands there. नहीं, ये तो इसके बारे में तो कोई बात नहीं होगी, क्योंकि इस लेवल पर प्राइम मिनिस्टर और प्रेसिडेंट की लेवल पर ये चीज़ें डिसाइड नहीं की जाती. Similarly, that on the very day Trappier gives an interview कि भाई ये तो अभी होने वाला है. Similarly, Suvarn Raju has said on record कि आप हमारे से पूछो ना, मैं चेयरमैन था HAL का और को बता सकता हूँ. So when the court does not want to go into all this, in fact, as you know, Arun Jaitley's own blog confirmed that the permission which was taken was retrospectively taken. That meeting was held, गलती से बेचारा लिख गया, and put it in his blog, revealed the truth for once. So why will you not do this? इसमें नेशनल सिक्योरिटी कहाँ jeopardize होती है और आपकी competence क्यों नहीं है? Similarly, is it or is it not a fact that the clauses on offset were amended with retrospective effect? We said this in the court. We asked the court कि इसका rationale, Attorney General से पूछिए इसका rationale क्या है? Including the exercise of undue influence. That clause was also changed.
All the anti-corruption clauses.
All the anti-corruption clauses were changed with retrospective effect. I mean, what is the rationale and what is the implication of this? How is national security jeopardized and how is the court incompetent to examine any of this? So, second point I want to make is that, and this is a complete misrepresentation. I'm using a strong word about quote, it is a complete misrepresentation of our position and of its own self. If you kindly see page 3, just one small sentence I will read. Prashant and Rahul have done a wonderful job in giving you a briefing paper. But just see, the court says, the 2 judges say, it does appear that the endeavor of the petitioners is to construe themselves as an appellate authority. How did we say we are to appellate authority? And then to determine each aspect of the contract and call upon the court to do the same. No, we didn't call you say that. It is an absolute fabrication. And we do not believe this to be the jurisdiction to be exercised. We also do not believe that we are the appellate authority. How do you come to this conclusion? So, it is, you shut your eyes by a so-called very high-sounding self-restraint on sensitive matters. And you misrepresent what has been told to you in writing and orally in front of the whole packed courtroom and put in such allegations against us. Second point is that not only were these facts not examined, and they were certainly within the competence of courts to examine, they, in the entire call and this Gogoi judgment, they keep referring to the original judgment. कि जी उसकी रिव्यू अब आप नहीं कर सकते, हमने ओरिजिनल जजमेंट में ये कह रखा है. As I had shown at that time, the original judgment was nothing but a cut and paste job. It was not only from the that sealed cover, but from those 4 or 5 pages which they gave even to us, the government, sentence by sentence, paragraph by paragraph, howler by howler, the Supreme Court had swallowed and released it as its own judgment. I can tell you, as a fellow journalist, I can tell you that if any one of our reporters had done this, you would fire him up and you would remove him from service. He is plagiarizing. He is plagiarizing with such great and exhibitionist incompetence. So, and as that release, Prashant just pointed out, is the howler about that Ambani company. And how did that howler arise? कि Anil Ambani की company is constituted only 12 days before the contract, है ना? And they say no, 2012 से ये talking चल रही है. वो थी मुकेश अंबानी की कंपनी और वो दोनों लड़ रहे हैं. पर उसको जनाब इस तरह कर दिया. वो कहाँ से लिया आपने? कहते जी डिफेंस मिनिस्ट्री की प्रेस रिलीज से. और डिफेंस मिनिस्ट्री की प्रेस रिलीज में क्या कहा गया है कि प्रेस रिपोर्ट्स से that means you have castigated us for relying on press statements by Subaran Raju, Trappier, the foreign secretary, now foreign minister, but you rely on a press release about press reports which are not even reproduced.
ये भी झूठ बोल दिया कि एयर मार्शल के प्राइस भी बोल दिया.
हाँ, वो तो बिल्कुल ही तो मैंने उस समय लिखा भी कि भाई हम कोर्ट में थे, उस जजमेंट में कहा we have had the benefit of interaction with senior personnel of the Air Force, and that was just a staged drama in which the Chief Justice kept asking them absolutely leading questions,
irrelevant questions. What is completely irrelevant questions were asked about some technical aspects of this aircraft and what is a 3rd generation fighter, 4th generation fighter, etc. Not one question, not one word about the price, and yet in the judgment they have said that this Air Force, senior Air Force officers came before us and justified the price. Totally false.
Not only that, how did he ask the question? Actually, there's been no induction in the aircraft, in the Air Force since 1985. Na? He said to those Air Force fellows, wo bachara, he knew that Sukhoi is being manufactured now in Bangalore and in another facility and is being inducted. It's a new aircraft, it is the state-of-art aircraft. How could he say 1985 se kuch nahi aaya? No, but nothing since 1985, na? वो बेचारा चुप खड़ा रहा. इसी तरह वो कहते हैं कि this Sukhoi, the 3rd generation aircraft, na? It's actually in the air shows, the Indian Air Force presents it as a 5th generation aircraft. The Chief Justice kept saying, 3rd generation, na? 3rd generation? Paranjay, 3rd generation? So he kept quiet. So he said, sir, maybe 4th generation. He said, 3.5 generation, 3.5 generation. Then the Chief Justice speaking from the bench, and he relied on this in judgment, saying, yes, we've had the benefit of interaction with the Air Force officers, and they have said this, that, and the other. It was a complete falsehood, a complete fabrication. So, as Prashant pointed out, the CBI is bound to act in accordance with Lalita Kumari and is bound to act in accordance with this judgment, which reiterates Lalita Kumari. And Justice Joseph has been has gone to great lengths to emphasize that while we have restricted powers, the court, the police officer in investigation has much wider powers than us. So why will they not do it? So that is my plea to all of us who are journalists and to watchdogs like Prashant, that we should now, of course, go to tell the CBI to act in this. He's right. We should watch what the CBI does and what are the grounds on which the government refuses permission, which it has usurped, that right it has usurped under 17(1)(a). That is one. And my last point is that actually we are very delighted, the three of us are very delighted with the course which this case has taken. The fact that the CBI did not act in accordance with law gave us an opportunity to bring it to you and to go to the court. The fact that the court gave such a ridiculous judgment. If the court calls me for contempt of court, I have my lawyer ready. So, such a ridiculous judgment, that gave us the opportunity to put further facts to the court by through our review petition. Now that they have not dealt with any of those facts and have hidden themselves under a burqa of self-restraint, self-manufactured restraint, yes, self-manufactured burqa. This shows that actually it's a wonderful opportunity, and I'll just quote, I'll just give you the example of a very great man, which has always been a solace to me as a journalist, and that is Gandhiji. You see, our duty is to bring the facts before. If anybody says, oh, my court to mani nahi, court ne to aapki petition dismiss kar di. No. If when you bring the truthful facts on record, if the court or any institution accepts those facts and acts accordingly on those facts, then one limited purpose has been served. But when the facts are so clear and the court fabricates something else and does not proceed, then you have done an even greater and more general service by showing to the people the state of this institution as well as all other institutions in India. Reserve Bank of India, Election Commission से भी आप रोज देखिए क्या इनकी हालत है. आपको बैंक्स के फ्रॉड में से पता लग रहा है कि सुपरवाइजरी इंस्टीट्यूशनल उनको फोर्टनाइटली रिपोर्ट हर एक बैंक भेजता है. तो वो क्या कर रहे थे जी INLFS पर. So the court is now actually, I think this, you correct me with the name, your senior advocate Ramachandran, Raju Ramachandran wrote a wonderful article, he and one other person wrote a wonderful article.
Arvind Lattar and Raju Ramachandran.
On Kashmir.
C.U. Singh and Raju Ramachandran.
C.U. Singh and Raju Ramachandran wrote a wonderful article in the Indian Express when the Kashmir episode came and people came to them with habeas corpus and other petitions. The ADM Jabalpur movement, habeas corpus case of the emergency, it is that movement for the Supreme Court. And you have seen, it is not that the petitions fail or the petitions have not been taken up in time and people have been rotting in jails. The fact is that the Supreme Court has shown that it has once again failed when confronted with the ADM Jabalpur movement. It is the same episode that has been reenacted by the way it has handled this matter of Rafale. Thank you very, very much. Thank you.